On the 22nd of May, 1975, Lord Denning, Master of the Rolls, presiding in the Court of Appeal that day, heard an appeal from the Commercial Court from Japanese ship owners who had applied without notice 2 days earlier for an injunction seeking to restrain defendant charterers from removing any of their assets from the jurisdiction. The ship owners had an outstanding claim which was for unpaid charter hire, which they said was unanswerable. The only tactic open to the defendants, they feared, was to put those assets beyond the reach of an enforceable judgment by removing them from the jurisdiction. Lord Denning granted the injunction that they sought, which commenced, in Lord Denning's words, the greatest piece of judicial law reform in my time. This form of injunction became known as the Mareva Injunction. However, the case that I just described did not involve a ship called Mareva. The case I just described was called Nippon Yusen Kaisha and Kara Georges. It wasn't until around a month later that on the 23rd of June 1975, Lord Denning granted a similar application, renewed on appeal, in Mareva Company Naviera SA and International Bulk Carriers SA, which related to proceeds of hire paid under a time charter for the vessel, the Mareva AS, which the applicants again felt were likely to be removed from London bank accounts out of the jurisdiction to avoid enforcement. And they sought an injunction to prevent this. It was that case that won the naming rights for this form of injunction, despite it being the second of its nature. And further, it was one that was not even widely reported at the time, given in fact there was nothing new in principle about that case. It was reported in the Lloyd's Law Reports at the time, given its nature as a maritime case, but it took 5 years for it to be added as an appendix to a full report of another case about injunctions in the All England Law Reports. But this talk celebrates that case, one of the nuclear weapons of the law, the Mareva Injunction, now known as the freezing order. The other nuclear weapon is the Anton Pillar order, also known as a search order, another one of Lord Denning's cases, which notably is also 50 years old this year, although I'll only have time, understandably, to cover Mareva today. My talk will be split into 2 parts. First, I intend to cover briefly the essential elements of a freezing order and how recent authorities have shaped those. I say briefly because each one of those elements could justify a talk individually. But what I want to do is also look forward, as the second part of my talk will consider 3 important changes brought about by the new model freezing order published by HMCTS and announced as part of the Civil Procedure Amendment Rules 2025, which also introduced a revised version of CPR 25. What are the fundamental elements of a freezing injunction? The court's power to grant a freezing order is contained in Section 37 of the Senior Courts Act 1981. That grants the court jurisdiction to grant injunctions where just and convenient to do so. It is that just and convenience test that is the backdrop to these applications and must always be considered. Generally, an applicant has had to show an underlying cause of action to obtain a freezing order. That is derived from the case called the Siskina, in which it was said that the right to seek a freezing order was dependent on there being a pre-existing cause of action against the defendant arising out of an invasion, actual or threatened by him, of a legal or equitable right of the plaintiff, for the enforcement of which the defendant is amenable to the jurisdiction of the court. However, after the Privy Council's decision in Broad Idea International and Convoy Collateral Limited, which was then endorsed by the Supreme Court in 2023 in Wolverhampton City Council and London Gypsies and Travellers, The Supreme Court had noted that there was a gradual but growing reaction over the past 40 years against the idea that an injunction must always be founded on a cause of action. And that culminated at that 40 years in the decision in Broad Idea. It was held that it is now well established that the grant of injunctive relief is not always conditional on the existence of a cause of action. Reference to the Shabra jurisdiction, in which a court can join a third party as a defendant where there's no cause of action against it, and grant a freezing order against it to support the claim against the primary defendant. And that's one which the Supreme Court noted in Wolverhampton as an example of an established exception to this rule. Now, an applicant must also demonstrate a good arguable case. Now, clearly, since Broad Idea, the good arguable case test must be interpreted slightly more broadly, given that there need not be that underlying cause of action. But there is a divergence of authorities on what exactly the good arguable case standard is. Initially, one line of authorities suggested it was similar to the serviced out of the jurisdiction context. However, the approach in the Niedersachsen was to express the test as being more than barely capable of serious arguments, and yet not necessarily one which the judge believes to have a better than 50% chance of success. Now, in 2024, the Court of Appeal held in Dos Santos and Unitel SA that the formulation as set out in the Niedersachsen applied, rather than the test in a service out gateway test. And that test is practically the same as the serious issue to be tried test for interim injunctions. Now, it's yet to obviously be seen whether Dos Santos is the last word on this issue. The applicant must also show a prima facie case that the respondent has assets in the jurisdiction and has control of those assets. Generally, these assets should be ones that are available for the execution of any subsequent judgment. That's known as the enforcement principle. Although it's recently been noted that that is not an absolute principle. Parties should always check to see whether those assets have any superior claims over which they could defeat a freezing order. Now, Mareva was initially concerned with assets being moved from England and Wales out of the jurisdiction. Where assets in the jurisdiction are insufficient, and the applicant has grounds for believing that assets exist outside of the jurisdiction, the court can grant freezing orders over those assets in specific countries or worldwide. Further, Section 25 of the Civil Jurisdiction and Judgments Act 1982 gives the court the power to grant injunctions in support of foreign proceedings. Clearly, the scope of a freezing order has widened significantly since Mareva. The applicant must show a real risk of dissipation. That is, a real risk that the respondent would unjustifiably dissipate assets such that enforcement would be more difficult. Solid evidence is required to establish a real risk, and the court assessed that objectively. Previously, a nefarious intent was required to be shown, but that test has not survived the test of time. There is, as we will go on to see, no unjustified dissipation of assets if they are used for the ordinary business purposes, ordinary living expenses, or obtaining legal advice or representation. The purpose is to capture unjustified dissipation, where assets are being dealt with in a way such as to make enforcement more difficult. Because of the draconian nature of a freezing injunction, an applicant is normally required to provide an undertaking in damages if it transpires that the freezing order should not have been made and the respondent has suffered loss as a result. An applicant might need to identify assets or fortify this undertaking if necessary, although the fact that an applicant cannot fortify that undertaking in damage may not be fatal for the obtaining of a freezing order. A freezing order is not one that is only available to those with the necessary funds to do so, because that would not be in the interests of justice. Now, freezing orders are often made without notice because if one suspects that assets will be removed to avoid enforcement, if a defendant gets wind of the intention to stop this removal, they may simply accelerate their plans to dissipate, to defeat not only enforcement, but the application for a freezing order as well. And therefore, as with any without notice application, the very serious duty of full and frank disclosure applies to the applicant. And a failure to comply with that duty has led to freezing injunctions being set aside at the return hearing. Whilst costs don't appear on the fundamental elements section of my slide, it is notable that the recent decision in the Court of Appeal in Dos Santos has held that the costs of a freezing injunction application do not necessarily need to be reserved to trial in the same manner as a conventional interim injunction. They are typically intended to hold the ring until trial. The Court of Appeal distinguished freezing injunctions in that case as not necessarily interim in nature or dependent on the balance of convenience. And so it cannot be said that it follows that a freezing injunction ought not to be granted if a claim fails at trial. And that's a slightly different approach to costs, therefore, than American cyanamide injunctions. And so that's a whistle-stop tour of freezing injunctions. But we move on now to consider the new model order. Pursuant to CPR 2514, an applicant must use the wording of the model order in the form approved, modified as appropriate, with such modifications drawn to the judge's attention at the application hearing. The new model order published this year draws parties' attention to this in the important note on the cover. So I intend to look at 3 changes arising from this new model order and highlight some practical tips that arise for those bringing or defending applications. The first is the definition of value. Now, freezing orders invariably come with asset disclosure orders. Otherwise, policing such freezing orders would be very difficult. Previous model orders required disclosure of value, location, and details of assets. Well, what exactly does value, location, and details mean? A number of authorities considered that point. In ADM International Sal and Grain House International SA, Lord Justice Popplewell noted that value for this purpose could either mean market or unencumbered value, but not both, and held that the application of the strict construction principle required disclosure only of market value in that case. Now, that case involved a freestanding asset disclosure order rather than one contained within a freezing order. Lord Justice Popplewell noted that a well-drawn disclosure order might include both, suggesting that modifications to the standard model order wording may, in certain circumstances, be appropriate to resolve that uncertainty. Now, in reference to other High Court authorities in which disclosure orders appeared in model freezing orders, Lord Justice Popplewell noted that the interpretation of value as meaning unencumbered value was justified because there were other references in the model order in that form. And he expressed that it would be desirable to amend the standard form to refer to unencumbered value to remove any room for doubt in the mind of a defendant without access to legal advice. And so the new model order wording, no doubt inspired by Lord Justice Popplewell's comments above, now requires at paragraph 11 disclosure of all respondents' assets in market value, ignoring charges or other security, and details of all charges or other security over such assets, including the amount currently secured thereby. Respondents must still give the value, location, and details of those assets. Now, in my view, there's still imprecision that arises from this wording. Digital assets, such as cryptocurrency and non-fungible tokens, which are now recognized as assets that can be the subject of proprietary and freezing injunctions. These new asset classes may bring up new challenges as to interpreting disclosure of their location or details. But those issues could arise for other asset classes as well. Amending the standard wording in the new model order to provide further precision in each relevant case will likely be helpful to avoid further satellite litigation. And so whilst the new wording is a welcome change because it is more precise, applicants are still encouraged to continue to seek to adapt the wording of the disclosure orders to suit the relevant case. We also now have in the new model order a new undertaking. That's at paragraph 10 at Schedule B, which reads as follows: the applicant will not, without the permission of the court, use any information obtained as a result of this order for the purpose of any civil or criminal proceedings, either in England and Wales or in any other jurisdiction other than this claim. Why is a restriction in collateral use of disclosure important in the first place? From the authority of Kolomoisky, in which Mr. Justice Trower notes two important policy reasons for why prohibition on the collateral use of documentation disclosed by compulsion exists. First, it recognises a person's right to privacy and confidentiality of their own documents where that privacy is interfered with by compelled disclosure. And it encourages, secondly, full and frank disclosure of all documents relevant in legal proceedings, whether helpful or not. Now, looking at the wording more closely, we see the first important words of this undertaking are without the permission of the court. The effect of this is that the undertaking remains effective until permission is given by the court for an applicant to be released from it. This has the potential to catch out, in my view, unaware applicants who seek to rely on the usual exceptions for collateral use contained in CPR 3122. That provision provides that the restriction on collateral use ceases to have effect where the document has A, been read to or by the court or referred to at a hearing which has been held in public, B, the court gives permission, or C, the party who's disclosed the document and the party whom the document belongs agree. So this undertaking is narrower than that, with the only exception for release being with the permission of the court. It might have been more helpful for the new model order wording to reflect that same provision, with the same exceptions applying and the onus being on the disclosing party to apply for the restriction to continue after documents have been read to in open court. Because this would avoid a strange scenario where a claimant who's obtained documentation through a freezing order would then be unable to use that after they've been referred to in open court, whereas a journalist or a member of the public sitting in the public gallery could. Now, whether the court would permit a departure from this wording regularly seems unlikely, and it may be something that could be amended in future model orders. The undertaking also applies wherever the party uses the information, the authority of IG Index, which shows how widely the word use is interpreted. All information contained within the documents that are disclosed, any information obtained as a result of the injunction, and the documents themselves cannot be used, for example, to form the basis of pleadings. Whilst it might seem an attractive litigation tactic to use a freezing order as an attempt to also obtain disclosure through the asset disclosure provision that would help you to formulate your cause of action, particularly for, say, in a fraud case, it appears from this undertaking that tactic is closed off. And so practitioners should therefore be wary of the heightened collateral use obligations imposed by this undertaking that appear to go beyond CPR 3122. And so if permission is needed to use documents or information obtained for other purposes, and need is sought for release from this undertaking, an early application is always recommended. Avoid having to seek such permission retrospectively, and also ensure that any unintentional breaches are guarded against. As noted previously, freezing orders protect against unjustified dissipation. They are not intended to be used as security or to be punitive. Exceptions, therefore, for spending in the ordinary course of business, for legal advice, and for representation, and for ordinary living expenditure are the usual carve-outs in freezing orders and have been contained within standard model orders for years. The new model order provides at paragraph 9.1 new wording for the carve-out for spending on legal advice and representation relating to these proceedings. And the associated footnote suggests that this square-bracketed optional wording may be appropriate where other legal advice and representation may fall within the ordinary and proper course of business exception, which is contained at sub 2. It also includes an optional advance notice proviso, which states, but before spending any money, the respondent must tell the applicant's legal representative where the money is to come from, and, optionally, approximately how much is to be spent. Again, the footnote suggests that this ought to be included only where really necessary, more particularly for where the amount to be spent is required to be notified, and that these are best sought on the return date. Now, a similar optional proviso, advance notice proviso, is present in sub 2, which deals with the ordinary and proper course of business exception and includes footnotes with similar warnings. So this new wording seems to assist applicants in policing a respondent's compliance with the freezing order and is, in my view, a welcome change for those bringing freezing order applications. And so in conclusion, the nuclear freezing order is showing no signs of slowing down in its development, with important recent authorities cementing it as a powerful tool in civil litigation. It has expanded in use in frequency and scope, being regularly deployed worldwide, and the new model order that has been published this year aims to keep pace with those changes, and practitioners should therefore ensure that they are aware of those relevant changes, including the enhanced collateral use obligation, the need to ensure relevant modifications to the standard wording, and that those are brought to the judge's attention where appropriate.